The moment you are arrested for a DUI in California, two completely separate proceedings begin. One is the criminal case in court. The other is an administrative action by the DMV against your driving privilege. They run on different tracks, with different rules and different timelines. The 10-day deadline belongs entirely to the DMV side, not the court side. When you were released, the officer took your physical license and handed you a pink document. Most people focus on the part that says temporary license, valid for 30 days, and never read further. But that same piece of paper is also the official notice that the DMV intends to suspend your license. The part most people skip is the part that starts the 10-day clock. From the date of your arrest, you have 10 days to contact the DMV and request an administrative hearing. The request itself is not complicated, but it has to be made correctly and on time. You or your attorney contact the DMV office that handles driver safety matters, identify yourself and the arrest, and request both an administrative hearing and a stay of the suspension. If you miss the window, the hearing is forfeited entirely, and the suspension takes effect automatically when that temporary license expires. There is no extension. Requesting the hearing does two important things right away. First, it generally stays the suspension, meaning the DMV typically extends your ability to drive past those 30 days while the hearing is pending. Second, it forces the DMV to prove its case. At the hearing, the DMV must show the officer had reasonable cause to stop and arrest you, that the arrest was lawful, and that you were driving with a blood alcohol level at or above the legal limit. Each of those elements can be challenged. Requesting the hearing is what opens that door. Here is one of the most important things to understand about this system. The DMV action is completely independent of the criminal case. Your criminal charges could be reduced or even dismissed, and the DMV suspension can still stand, because the DMV decided it separately under its own rules. The 10-day deadline does not care what the prosecutor eventually does. Waiting for your court case to develop before dealing with the DMV is exactly how people end up with a suspended license, even when the criminal case goes in their favor. If the suspension does take effect, the length depends on your history and whether a refusal is alleged. A first offense administrative suspension is typically 4 months. Many first offenders can obtain a restricted license fairly quickly, and installing an ignition interlock device is one option that can allow fuller driving privileges during that period. Though on a first DUI with no injury, it is generally a choice, not a mandate. A restricted license without an IID, limited typically to work and DUI program driving, is also an alternative. The point is that doing nothing forfeits both the hearing and any early control you could have had over the outcome. If you were arrested recently, treat that clock as already ticking and do not wait for your court date to deal with it. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.